Hello and welcome to The View from 22. I'm Michael Simmons. Now, normally on this show we tend to look at slightly more light-hearted issues, but today we're looking at something really quite serious, and that's the trial and retrial of the convicted baby killer Lucy Letby. Now, she's just been convicted again on a retrial for another count and had another full life sentence added to the sentences that she's already serving. She's also had her requests for an appeal denied. One person who's been writing about this and calling into question the safety of her conviction is the Mail on Sunday's Peter Hitchens. He joins me now. Peter, Lucy Letby sat through what was the longest murder trial in English legal history. She's now been convicted by two juries and had her request for appeal denied by a panel of judges. What is the issue here?
Well, the issue is the issue which is always the case with our justice system, which is, of course, because of the huge power of jury verdicts, because you have actually been convicted by a jury of your peers, the force of the conviction is much greater than if it had just been done by some appointed state panel, and immediately most people will consider the issue to be closed, which is not unreasonable. That's the purpose, in some ways, of having juries, that it's fairer and more independent. But things can still go wrong with jury trial. And we have most recently had the case of Andrew Malkinson, who endured 17 years in prison for a crime he simply did not commit, and which there was a lot of evidence which showed he did not commit it, which somehow or other didn't get considered, and enormous efforts were necessary before he was released, and even then the system was quite grudging about it. So I don't, much as I would love to say that the English justice system is perfect, because I am myself a great defender of jury trial, and of everything about the English system, I know that it's not from experience. There are the other cases, of course, particularly the Birmingham Six, which took very, very long periods for people to recognise, were extremely faulty. The system initially will circle its wagons and generally say no. There's nothing particularly new about that. And jurors can get it wrong. And therefore, if you think that they have, because it tends to take a very long time to get anywhere with this, and because of the idea to me, and I imagine to you as well, of an innocent person, possibly innocent person, suffering in a prison, particularly under the circumstances in which a convicted child killer would suffer, is unendurable. And to wake each morning and go to bed each night and to know that someone is in that condition is unendurable to the civilized conscience. So you have to say, I need to know, is this conviction safe or not? And I think it needs to be re-examined.
This was the longest murder trial in English criminal history. It went on for 10 months. There was loads and loads of evidence. There was witnesses. The jury sat all through this. What we have is the decision of that jury, the decision of two juries, the decision of judges now versus speculation from parts of the media, speculation from the internet. Why do you think it's unsafe?
I think it's much more than speculation. I think if you read Rachel Aviv's long article in the New Yorker, which is now available in this country, you can see it's much more than speculation. She actually got hold of the transcript of the entire trial and read it and did a number of other very serious investigations. And I don't think anyone can really impeach the New Yorker for being a frivolous publication. It has very, very intensive fact-checking, even after all that is done. And I think the article makes an extremely persuasive case for reopening the conviction. And I think anybody who reads it does. And then this has now been followed, because after the end of the second trial, there's a dam burst of criticism of the way in which the trial was conducted and the way in which evidence was presented has appeared in both The Guardian and the Daily Telegraph, two newspapers at the opposite ends of our political spectrum. Both of them seen fit to publish lengthy, how shall I put it, dissent and criticism of the way the trial was conducted. I think there is a major problem here, and I think it would be idle to ignore it. What could possibly be wrong with allowing an appeal?
Lucy Letby's defence asked to appeal on four different grounds, including attacking the prosecution's expert witness, including saying that one juror's potential biases were not properly examined. The judges went through all four of those points and found no issue. Shouldn't we have more faith in the system that actually they've got this right?
Well, the right of appeal at all has only existed for quite a short time in English legal history. When it was suggested that we should have such a process, a lot of people said, well, this called into question the safety of jury verdicts, and eventually we came around to the idea we could have appeals. It's quite reasonable for judges and appeal courts to be reluctant to accept that anything's gone wrong, and they will, in my view, generally do so unless some huge error by the judge has been discovered, which it hasn't. And I'm not particularly surprised by this. In fact, in almost any case you care to name, the initial response of the justice system to any suggestion that's got it wrong is to say, no, we didn't. I'm not bothered by that. I still think that the evidence against Miss Letby is unsatisfactory for a conviction, and particularly unsatisfactory for keeping this person locked up until she dies, which is the sentence of the court, and it's not changeable.
But what is unsatisfactory about the evidence? Because
right. Okay. Well, now we get to the point. What's unsatisfactory about the evidence is that it is so speculative that we have theories being put forward about how the babies might have been murdered, babies which in many cases, not all cases, were the subject of autopsies and in which no sign of foul play was found. And we have also the statistical point on which the prosecution relied quite heavily of Lucy Letby's presence at so many of the occasions where babies died. But this has also come under considerable criticism from statisticians. Indeed, before the trial began, following the very similar trial of Lucy de Burke in the Netherlands, a paediatric nurse who was also sent to prison for a very long time for killing babies, which it later turned out she had not done, or certainly could not be proved to have done, the Royal Statistical Society actually produced a quite lengthy pamphlet saying that there was a danger in trials of this kind that people would get it wrong, and urging them to adopt procedures which were not adopted at this trial.
But do you not think that those advocating for Lucy Letby, or the idea that this may have been a miscarriage of justice, are actually relying too heavily on this statistical evidence, the idea of the work schedule, that she was always there? Because for two reasons, as we keep saying, this was a 10-month trial. They didn't spend 10 months looking at a spreadsheet. There was other evidence.
Yes, there was. But it was all pretty much on the basis that if you accepted that she was guilty, then everything that was advanced by the prosecution made sense. If you didn't accept it was guilty, then it isn't quite so clear. And also on the statistical side of things, I don't think there's very much doubt that for instance, there were other deaths on that ward at the time which she was not present, which are not included in the spreadsheet. So how on earth can the thing be made to work? And it's not really in question that the spreadsheet evidence is dubious. I'm not attempting here to attack anybody.
But I think you can't. The spreadsheet evidence, I think, can be defended, because even if you say statistical coincidences happen, which they of course do, this just seems it's a coincidence upon a coincidence. When she moved from her night shifts to the day shifts, the deaths moved with her. When she went on holiday, on annual leave, the things calmed down on the ward. How do you explain that?
Well, I can only say that people far more qualified. I'm not an expert. I'm a journalist, and just as I would point out, the judge was not an expert, the jury were not experts, prosecuting counsel weren't experts. But I would say that, as I say, particularly in the articles published in the Guardian and Telegraph in the past few days, the validity of the spreadsheet statistics is called into question in a way which it wasn't, in my view, called into question during the trial.
But even if we look before the trial, the people who were experts investigating this, the police, when they were finally called in, they didn't come in and say, some concerns have been raised about Lucy Letby, we're going to look at her cases. They had individual separate officers looking at each suspicious death, not talking to each other. They all separately came to the conclusion that there was suspicions about Lucy Letby, and then the case built from there.
Yes, that's okay. I completely accept that. And there were suspicions, and there can be suspicions against anybody. Many people could fall under suspicion. And once people start investigating matters which appear to be suspicious, then they will pursue them, and that's the nature of inquiries. These things then come to trial, because at trial we're supposed to examine these suspicions and see whether they add up to evidence enough to send somebody to prison. As I say, I don't at the moment think that I've seen enough evidence to suggest that she should have gone to prison. I'm not in any of these cases. Anybody who takes up any sort of case of injustice has to have in his or her mind the possibility that the person they're defending is guilty. You have to have an open mind. At no point am I going to say to you, Lucy Letby is innocent, or even that I think Lucy Letby is innocent. I'm in no position to know either of those things. I'm not even aiming at that. The point is, in the English justice system, and it is one of its glories, she doesn't have to prove that she's innocent. The Crown has to prove that she is guilty beyond reasonable doubt. And my suspicion is that they haven't actually done so. And I think that no harm whatever would be done, given the huge amount of suspicion, not from conspiracy theorists or marginal people, but as I say, from mathematicians, scientists, and all kinds of and doctors, that there are faults in this trial. There's absolutely no harm to be done in re-examining it and allowing an appeal.
But isn't it actually, a lot of this has come from very online people, be they scientists, mathematicians. It's still come from online reporting of the case. It's not come from people
I simply don't agree with that. I think that particularly the New York article and the lengthy coverage in the Guardian and the Telegraph this week, it simply can't be categorised as that. These are serious people.
None of the pieces that have been written about it, none of the commentary about it can go into every stage. So inevitably, they miss out little bits. And certain things are not addressed, such as the fact that Lucy Letby's defence and Lucy Letby herself conceded at trial on the stand that at least some of the babies had been harmed, just not by her.
Well, I'm puzzled by this. I don't see what evidential value it has for her to say that. How could she know?
Well, in her medical opinion, now
how could she know if they'd been harmed? I mean, it doesn't seem to me to be central to the point. I'm not proposing that all the people who are in favour of Lucy Letby having an appeal should gather together with pitchforks and advance upon the prison where she's held and forcibly free her. I'm saying that our justice system has both the Criminal Case Review Commission and the Appeal Court, through which cases which are causing concern can be re-examined. And I'm saying this is a case where re-examination seems to me to be very much called for. I don't see how that can possibly be unreasonable.
But should we not have more faith, in this system, our jury system?
No, absolutely not. It's not. Faith is for God, and faith is also for the unknowable. What we can examine in these cases, the evidence which is put forward. And we can say, does this evidence add up to proof beyond reasonable doubt that the person involved is guilty? I think there are serious doubts have been raised in serious places about this, and that those doubts should actually be the subject of a proper appeal.
Separate from the Lucy Letby case and separate to whether she is granted an appeal or not, do you think this has highlighted, wider problems with our prosecution system, with the court system, or is this very unique?
Oh, I think there are problems. I think there have been for some time. I think there's been a tendency increasingly, particularly for prosecutors, to rely very heavily upon emotion and less heavily upon forensic fact. But that's a personal feeling I've had watching. I cut my teeth in journalism reporting court cases in magistrates and Crown courts, and it seems to me to be different from the way it was when I was doing it back in the 1970s. And I think there's certain other bits of procedure which tend towards that. I'm not entirely sure that things are as good as they ought to be, no. But that's a much more general point. I make no particular point about this case.
And is there, and on the general point, is there an alternative? Is there a better system? I mean, a totally different kind of case, but the Scottish government have been for some time trying to bring in juryless trials for sexual offences.
No, that would be terrible. And the jury is the only thing which stops a trial from being a committee set up by the state to decide how long to send you to prison for. The jury introduces into the trial the element of actual dissent, which allows there to be a serious defence which has to be listened to. I would absolutely oppose any attempt to get rid of juries, and I don't think that would be the point at all. No.
But that brings us back to the core of this. That this jury saw more evidence than anyone writing for the New Yorker, anyone in the Guardian, or anyone in the Telegraph, you or I, and they have made this decision. And they didn't, unanimously convict on all counts.
No.
They clearly considered things.
No, I'm not. I have no criticism of the jury. I hugely sympathise with them faced with this awful case, and I don't attempt to criticise them. But I would maintain that it's perfectly possible, and this has happened in history, for juries to get things wrong, just as it's possible for judges to get things wrong, and indeed for the police to get things wrong. And we shouldn't close our minds to the possibility. And we have lawful, functioning mechanisms to deal with it when there is a widespread feeling that something has gone wrong, and we should use them. And I think, as I say, I'm disappointed by the appeal court. I hope that they can be persuaded otherwise.
And do you have hope for that? Do you think?
Well, I don't know. The great problem with cases like this is that sometimes it can take years. The other injustice in which I was involved, which was over the false accusation made against a dead bishop, took ages simply to get to the first base of anybody admitting there might be something wrong with it. I'm used to the fact that this thing takes time, but I'm not by any means the only person who's concerned about this case. And I think if enough head of steam grows through, then I think eventually we will, and quite rightly, see that it's re-examined. And a good thing too. I can see no argument against re-examining it. Absolutely none. You should never begrudge any time or effort into making sure that people who are being punished in our prisons are there because they ought to be.
But we can't automatically, re-examine everything. Just as before conviction, there's rightly a presumption of innocence. There surely has to be after conviction, a presumption of guilt.
Well, that was the case before the appeal court got going. I think in the 19th century that it was presumed that was it. If you were guilty, you were guilty. I think we've had enough miscarriages, and I raise again the case of Andrew Malkinson. Had enough miscarriages, both in the distant past and in the recent past, to know that juries can get it wrong, and the police can get it wrong, not out of malice, but simply they can get it wrong. There are forms of groupthink. There are ways in which people, once they've decided that a case is of a certain character, they pursue that. They become single-minded about it. This is well known, and it's important. It's important that we have people who are single-minded about pursuing cases, because otherwise prosecutions would never happen. But sometimes this can go wrong.
But there's an established bar for re-examining a case, which is there has to be, absent of some legal error of the judge or something legally wrong in the trial, there has to be new evidence that wasn't available at the time that disproves guilt. Do you think that there is a too high bar?
There is some new evidence that was presented to the appeal court about the discoloration supposedly being evidence of air embolism. Let's not get too technical here, but I think that the view of the appeal court was that the defence should have presented this at the time.
Yeah, and if
it seems to me to be new evidence.
But if it was
it just does, and so
that comes down to.
But the phrase new evidence is the appeal court decides what is and what isn't new evidence, isn't it?
But it's new evidence if it was not available to the defence. If the defence had it at the time and chose not to use it, then it's.
It's an interesting concept, that, isn't it? I mean, you say, for instance, if you'd been put into jail for the next 25 years and you were sitting there, and you discovered that your lawyers during your trial had not put forward a vital piece of evidence which might have got you acquitted, and the appeal court said, well, it's very interesting, but because they didn't present it at the time, it doesn't count. What would you think?
Well, I think, yeah.
You think, hang on a minute, am I here because I'm guilty, or am I here because it would upset the procedures of the English justice system to let me go?
But Lucy Letby is entitled to make an argument that she had an incompetent defence, but she's not. She's not making that.
I don't imagine that would. I don't imagine that would. I don't imagine that would produce much good for her or anybody else. So you can see why anybody wouldn't want to do that, and I'm not suggesting that the defence is incompetent.
The only conclusion then is that any evidence they had which they didn't use at trial was because they thought it would not help their case.
Well, maybe so, but what I'm saying is look at the evidence that we're talking about, which the appeal court judges, I believe, heard from a Canadian a Canadian doctor who's an expert on this particular area, and ask yourself whether it oughtn't to have been before the jury.
This case, more than sort of many others, seems to have very quickly had, this media coverage you talk about of scepticism of the case earlier on than we have seen in other miscarriages of justice. Do you think that's a healthy new scepticism, or are people just completely losing faith in the British system?
I have no idea. I just felt uncomfortable about it during the trial. And when the trial was over, I was able to say so. And then for many months, I wasn't able to say so. And now I am again. I am uncomfortable about this trial. I am uncomfortable about the verdict. I think it would be very, very wise for our justice system to re-examine it.
Peter, thank you.